An Oklahoma City police officer hurls an elderly Asian man to the street after the man strikes him lightly on the chest, causing serious head injuries, and it's all captured on video. Can this police use of force be excused under qualified immunity? Let's talk about it. And for those of you who stay to the end, I'll share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict class coming up in just a few weeks. So elderly Vietnamese driver Lic Vu was apparently involved in a modest fender bender after making an illegal driving maneuver that resulted in another driver hitting his vehicle. A responding Oklahoma City police officer cited the other driver only for having an expired registration tag and sent her on her way. The officer then wrote out a ticket to Vu for his illegal maneuver. Vu, however, became argumentative about signing for the ticket, believing that he was without fault and that the other driver ought to be held responsible for striking his vehicle. Throughout Vu's verbal exchange with the officer, it's clear that Vu had a very limited grasp of English. It's hard to say how much Vu's advanced age may also have contributed to the difficulty in communication, though it wouldn't surprise me if that played a role. In any case, both Vu and the officer are captured on the officer's body-worn camera as becoming increasingly irritated with each other. At one point, Vu appears to hit the officer's chest with his hand in a manner I would characterize as offensive, but not really threatening. There simply wasn't any force behind it. Vu may also have said something along the lines of "shut up" to the officer. At that point, the officer decides to place Vu under arrest and grabs Vu by the arm in preparation for handcuffing him. This, by the way, would have been a perfectly lawful arrest at this point. It's unlawful to commit a battery on a police officer. In many jurisdictions, it's a felony. And assuming that Vu did, in fact, strike the officer, and it seems apparent he did, however lightly, that is still a battery on an officer. Just because an arrest may be lawful, however, doesn't mean the arresting officer is privileged to use whatever degree of force he wishes. Indeed, the officer is required to use the least degree of force consistent with safely securing the arrest. Any force beyond that would be legally excessive and unlawful. An instant after the arrest is initiated, the officer's body-worn camera shows Vu going to the street. There he's handcuffed and appears to be unconscious. A woman accompanying Vu, apparently his wife, with a somewhat better but still limited English-speaking ability, urges the officer to call for an ambulance, which he says he'll do. I've seen news reports in which the officer is said to have reported that when he grabbed Vu to initiate the arrest, that the elderly Vu simply fell to the ground and that the officer followed him down. If so, then Vu hitting the ground would not have been the result of an intentional use of force by the officer, but rather just an accidental fall. This narrative is, in fact, not inconsistent with what was captured on the officer's body-worn camera. Let's take a look at the relevant portion of that. The full-length body-worn camera video released by the Oklahoma City Police Department will be included in the Law of Self-Defense members-only version of today's show, but here I'll just share with you the relevant clip.
She hit us.
I understand that, but you're not. You see where that car's at? Whenever you enter that area, that's what you're supposed to do. You're not supposed to leave any space at all. You're not supposed to leave any space at all.
You see that two car?
Yeah, that's what you're supposed to do.
I am the
The way where your vehicle was located, your vehicle was not like that.
Sit up.
No.
You sit up. Get on the ground.
No. See, sir. No. Call an ambulance. I need the ambulance.
Yeah, I'm gonna call an ambulance.
Look at his head.
112 Hefner, roll me fire and incident supervisor.
All right, so when I saw that body-worn camera clip and I saw the officer's statement about how he went hands-on with Vu and Vu just basically fell to the ground and the officer just followed him down, okay, that seemed pretty consistent to me with what I see here on this body-worn camera. The body-worn camera video is not, however, the only video of the arrest. A nearby surveillance camera also captured this moment, and it tells a very different story. One in which Vu is spun to the street with extreme violence by the arresting officer. By the way, this is a good reminder that what the cameras see and what our eyes see and what witnesses see can all be quite different. Let's take a look at that surveillance camera footage as well. Now, I will say I've modified the wide-angle view of the original of this video to focus in on the arrest, but the original of the video with the broader view will also be included in the Law of Self-Defense members-only version of today's show. So here we go. There's no audio on this, so we're just watching the interaction. Vu is pointing out at the street. The officer points, and we'll see Vu strike the officer's chest with the back of his hand right there, and the officer makes the arrest. That vicious spin to the ground, in which Vu struck his head on the ground, lost consciousness, and suffered what I would characterize as serious bodily injury, is the problem here. By the way, here's the statement from the Oklahoma City Police Department on this event, so I should share that with you. They released it when they released these videos. It reads, "The Oklahoma City Police Department is investigating a use of force incident involving an officer, and today we are releasing video from the case." That's what we just saw. The incident occurred on October 27th, 2024, when an officer was involved in an encounter while investigating a traffic collision. During the officer's investigation, there was a use of force and an elderly man sustained serious injuries that required hospitalization. An investigation was immediately initiated, and the officer was placed on administrative leave pending the conclusion of the investigation. The incident remains under investigation and will be presented to the Oklahoma County District Attorney's Office soon. Okay, so this officer in this incident is explicitly facing the prospect of criminal culpability here, as he should, in my view. As I already said, the arrest itself is certainly lawful in response to the battery upon a police officer. The amount of force used, however, certainly seems grossly excessive under the circumstances. While this officer would not have known that Vu was exceptionally vulnerable to injury as a result of being a cancer patient, Vu's elderly condition is certainly apparent to the naked eye, and that alone would make Vu more vulnerable to injury than, say, a healthy 20-year-old suspect weighing 200 pounds. Any threat offered by an apparently unarmed Vu would also be modest given his age and physical condition. Again, the amount of force an officer might reasonably use to secure the arrest of a healthy 20-year-old suspect weighing 200 pounds to compel compliance with lawful arrest is substantially greater than would be reasonable to secure the arrest of an apparently frail, elderly man. Most condemning for the officer, however, is that this surveillance video of the arrest is completely at odds with the officer's own self-serving statement that Vu simply fell to the ground and the officer just followed him there. It's quite obvious from the surveillance video that the officer intentionally and forcefully spun Vu to the ground. The consequences of Vu's impact with the ground were substantial, including a life-threatening head injury involving bleeding on the brain. Photos of Vu's hospital stay are compelling evidence of the serious nature of his injuries resulting from this arrest. Now, police are allowed to use force to compel compliance with lawful arrest, but again, they are obliged to use the minimum level of force actually and reasonably necessary to secure that arrest, consistent with safety. This violent spinning of Vu to the street seems patently excessive under the circumstances and therefore is unlawful. It would not surprise me in the least, and it would seem both appropriate and necessary, that this police officer ends up criminally charged and personally civilly sued, with the results being both conviction and liability. Given that he was obviously acting on behalf of his department at the time, I would expect a lawsuit against that department to be similarly successful. All of that should be obvious even to a layperson with no training in the law. The apparently more ambiguous and misunderstood legal question, however, revolves around the question of the invariably misunderstood legal doctrine of qualified immunity. Is it possible that this officer's use of force could be excused, both for purposes of criminal culpability as well as civil liability, under the doctrine of qualified immunity? The answer is no, if qualified immunity is properly understood and applied. Unfortunately, it seems most people rather grossly misunderstand both the purpose and application of qualified immunity. In part, I have to say, because qualified immunity has sometimes been applied by the courts to excuse police conduct that ought not be protected under qualified immunity. Now, as a preliminary matter, qualified immunity cannot protect this police officer from criminal culpability because qualified immunity simply has no application to criminal conduct. To the extent the officer's conduct was criminal, and it certainly appears to my eye to be criminal, he can find no shelter within qualified immunity because qualified immunity is limited to civil liability. By the way, I'm going to start using a legal term of art here, so I ought to explain that term first. The term of art is a tort, T-O-R-T, and it refers to conduct towards another person that creates civil liability. We all have a generalized legal duty to not cause unjustified harm to others, and when you cause such unjustified harm, you have committed a tort and are civilly liable for monetary damages. This kind of conduct is also referred to as tortious conduct. So understanding that qualified immunity applies at most to civil liability only, could the doctrine apply here to excuse this officer's apparent tort against Mr. Vu? To understand this, we need to understand what qualified immunity actually does and what it doesn't do. And what it doesn't do is simply excuse police officers from civil liability for anything at all that they wish to do. It's not a universal get out of liability card. The very doctrine of qualified immunity exists because police officers have a rather unique job within our society. They are empowered with the authority to use force on behalf of the government. Now, I'm limiting myself here to the criminal justice context. The military context is obviously quite different. In fact, there's a technical legal term of art that refers to this unique status: under color of law. When an officer is using force under color of law on behalf of the government, he's obviously acting as an agent of the government. Indeed, using force on behalf of the government is precisely what society pays that police officer to do. It's his job. Now, if a non-police officer like me were to approach someone on the street, give them a bunch of orders, grab them by the arm, and put handcuffs on them, I'd almost certainly be committing criminal acts. I'm assuming here there'd be no pseudo-police authority such as citizen's arrest. I could readily find myself charged with assault, battery, even felony unlawful imprisonment. In addition, assault, battery, and unlawful imprisonment are not only criminal charges, they're also civil complaints, torts. So I could not only be criminally prosecuted, I could be sued for damages resulting from those tortious acts. Limiting ourselves to qualified immunity in the civil context, because as I've already mentioned, it doesn't apply to criminal conduct anyway, how does all this work and why? First, how qualified immunity works. Qualified immunity works in that if a police officer is committing an otherwise tortious act, it would be tortious if I did it, but doing so within the scope of his duties as a police officer, as an agent of the government, using force lawfully, not criminally, on behalf of the government, the officer is deemed to be immune from civil suit for that otherwise tortious conduct. Now, this doesn't mean that the suspect upon whom the force is used doesn't have any means to recover damages for civil liability. Qualified immunity protects only the individual officer from civil suit. It doesn't protect the officer's department. So as a result, the suspect would sue the police department rather than the police officer. Even better, that lawsuit against the department would typically be what's referred to as a Section 1983 lawsuit in federal court. And under Section 1983, the liable department would also be obliged to pay for the suspect's legal fees as well as damages. So the suspect's attorney, if successful, gets paid by the police department that they sued. So the suspect harmed by an arguable tort committed by a police officer can still sue for damages and be made whole in civil court. But the officer himself is excused from that suit under qualified immunity, and the department remains on the hook. The second part of the question is, why have qualified immunity in the first place? Well, a police officer working in a community with a meaningful crime rate might find himself using force in varying degrees many times per shift. That force might be simply going hands-on to compel compliance with lawful arrest, all the way up to the use of deadly force in defense of himself or others. But even if we limit ourselves to simply going hands-on to compel compliance with lawful arrest, every time a police officer touches a suspect for even this lawful purpose, an argument can be made, a claim can be made that the officer has just committed a battery, and battery is a civil offense as well as a criminal offense. So every time a police officer puts hands on a suspect, he could suddenly be liable to a lawsuit filed by that suspect for civil battery. Even if we assume that every such civil suit for battery would ultimately result in the officer's favor, because the use of force was lawful, the very process of defending against the civil suit is enormously costly and time-consuming. And defending a civil suit for a single battery could easily result in thousands of dollars in legal expenses. Forget about the risk of an actual judgment, and the risk of a judgment is never zero. That's part of the noise in the legal system. Now, imagine a typical officer might go hands-on with several suspects and incur potential civil liability and the enormous cost of a civil defense every time he goes hands-on with the suspect. That might be perhaps a half dozen times a shift, 5 days a week, 50 weeks a year. That works out to 1,500 potential civil suits a year. Assuming a modest $5,000 per suit in legal defenses and zero risk of an actual judgment, that amounts to $750,000 in civil legal expenses a year for a job that on average pays 1/10 that much in annual salary. And if even a single judgment is realized, there goes the officer's home, his kid's education fund, and every other asset he may ever have accumulated. No one could remain a police officer while facing that level of potential liability for engaging in conduct the use of force on behalf of the government that is a requirement of the job itself. The legal doctrine of qualified immunity was created to address precisely this dilemma by creating immunity from torts premised on the officer using force within the scope of his duties as a police officer. If someone files a lawsuit against a police officer and his department for a use of force event, the officer can quickly raise the doctrine of qualified immunity to argue for his personal dismissal from that lawsuit. Note, the department remains on the hook. If the presiding judge agrees that the officer's use of force falls within the scope of his duties as a police officer, he is dismissed from the case under the doctrine of qualified immunity. And again, the department remains on the hook. The department, of course, is much better positioned to defend against the high risk of civil suits inherent to a profession obliged to use force on behalf of the government. They have the staff, the lawyers, the resources, and they're also much better positioned to actually pay meaningful damages in those cases where genuine liability is found for the use of force event, or to simply settle the case for some agreed upon damages without having to incur the cost of a full-blown civil trial. So note that the phrase is qualified immunity, not simply immunity. Not all conduct of a police officer qualifies for qualified immunity. In particular, if an officer's use of force falls outside the scope of his duties as a police officer, that conduct would not qualify for qualified immunity, and the officer would remain personally liable for that tort. Of course, whether an officer's conduct qualifies for qualified immunity or not is a decision made by a presiding judge in a civil case in which the officer is being sued for a purportedly tortious act. And this is what leads to much of the misunderstanding about how and why qualified immunity works, because judges are imperfect human beings, like all human beings, and sometimes they rule poorly on questions of qualified immunity. A further problem might simply be that judges are themselves not well educated on the proper scope and limits of the doctrine of qualified immunity. The result is sometimes qualified immunity is improperly applied to relieve officers of liability when the officer ought not have been relieved of liability. This is an improper application of qualified immunity. But the people who don't understand the difference between proper and improper application of qualified immunity, it leads to the perception that qualified immunity is blanket immunity, an inherently bad policy. That's not the case. Reasonable people might agree or disagree on whether qualified immunity is good or bad public policy, but this is a coherent debate only when those people have an understanding of what qualified immunity actually is, and not a gross misunderstanding. Of course, this applies to many things in life. Medicines are good. They save lives. But some medicines can also be used for ill purposes, such as to poison someone or to cause drug addiction. That medicines can be abused doesn't make medicines inherently bad, it makes their abuse bad. Similarly, qualified immunity serves a legitimate public policy purpose. It seems unlikely that society can even have professional police departments without qualified immunity or some equivalent legal doctrine. And while irrational and bigoted cop haters exist in substantial numbers, I expect most thinking people realize that police serve a useful function in society. Of course, qualified immunity, like any legal doctrine, may be subject to misapplication or even abuse. That this is so doesn't make qualified immunity properly understood inherently bad. It makes the misapplication or abuse bad. So bringing things back to Mr. Vu, had this Oklahoma City police officer limited himself to using the force necessary to compel Vu's compliance with lawful arrest, his use of force would fall within the scope of his duties and be covered by qualified immunity. And if Vu had wanted to sue, he would have been free to do so, but he would have been limited to suing the Oklahoma City Police Department, not the individual officer. In this case, however, the surveillance video makes clear that the force used on Vu by this Oklahoma City police officer was outrageously excessive under the circumstances. That places this use of force outside the scope of his duties and leaves the conduct unprotected by qualified immunity. So I expect this officer will be found personally liable for the substantial damages he caused Vu, in addition, of course, to whatever separate liability the department also bears. And also would not surprise me if this officer found himself criminally prosecuted for this event, in which context qualified immunity would play no role at all because qualified immunity doesn't apply to criminal conduct. So the answer to the question, does qualified immunity protect this use of force by this Oklahoma City police officer upon Mr. Vu? The apparent answer, in my view, would be absolutely not. Okay, folks, before I wrap up, I do want to share with you how you can join us for our 100% free Law of Self-Defense Hard to Convict class coming up in just a few weeks. As the title suggests, this free class teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The class is live streamed by me. It's taught live. It's not pre-recorded, and there's plenty of opportunity for Q&A. Again, the Law of Self-Defense Hard to Convict class is 100% free, but we do limit the number of seats to allow for adequate Q&A opportunity with the attendees. So I urge you to grab your seat right now before they're all gone by signing up at lawofselfdefense.com/hard-to-convict. And I'll close out by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law as well, so you're also hard to convict. Until next time, I remain Attorney Andrew Branca for the Law of Self-Defense. Stay safe.